Well, hello everyone. My name is Sondra Douglas. I am of counsel at Stein Sperling.
And I am Rama Taib-Lopez. I'm also of counsel at Stein Sperling, and we are both family law practitioners in our family law department.
And so we're coming here to talk to you today about there's some recent changes in Maryland law that we wanted to share with you all. We both practice family law, and one of the main changes that is going to be imposed as of October 1st of 2023 is that Maryland is going to follow many other states in establishing grounds for a no-fault divorce.
Yes, this is probably one of the biggest changes in family law in quite some time. It's been a long time coming. This was coming down the pike in the General Assembly, and this is a move that makes Maryland one of the, now following the majority of states in the country, that allows parties to file on the grounds of irreconcilable differences. So come October 1st, 2023, what are the grounds for divorce in the state of Maryland?
So after October 1st of 2023, you can get a divorce based on mutual consent. That still has not gone anywhere, which means you still have to have that agreement done in order to qualify. You also must be living separate and apart for 6 months. And then there's the irreconcilable differences, right? Which is not getting along is the third ground.
Right. What we hear all the Hollywood celebrities file for divorce.
It's a way of, I don't want to tell you all of my business. Irreconcilable differences.
Those grounds.
And if you say, well, what is separate and apart? There used to be a time where separate and apart was having two separate addresses, but that is no longer the case. The court understands that due to economic circumstances or various circumstances, couples may still be living under the same roof, but they're not holding themselves out to the community as husband and wife. And this gives them an option to get a divorce rather quickly based on no fault, saying it's not anyone's fault.
Yeah, so I think the question that's going, time will tell in this situation what's separate and apart, how that's going to be applied by the courts, and if you're a couple that's still living under the same roof, how the court's going to apply that, what requirements they're going to have you show in terms of, well, do you still pay household bills together? Do you still maintain joint accounts? Those are the types of questions that they may ask to make sure that you fall within this, whether you're eligible for these types of grounds for divorce. But it is a move. It is a move forward. A lot of jurisdictions don't require parties to be living separate and apart under two roofs, and this changes that, where they understand, like you said, that economic circumstances may have required people to still maintain the same abode, so to speak, but they're not necessarily really living as husband and wife together anymore.
What do you think about that client that comes in the door?
Right.
Who would we use it for versus who we would not use it for?
Right, so I mean, it's terrible to say this because we say this for most of our clients, and it drives our clients crazy because it is such a lawyerly answer, but it depends.
It really does.
It depends on, every family is different. I feel like every family, I always say this, every family is like a fingerprint. Every family is different. And it, depending on the circumstances of the family, it may, behoove a couple to file under those grounds, and it may not. It may behoove them to wait until they are truly separated from one another to file for divorce. But it's going to depend on meeting with the client, understanding their needs and their circumstances, understanding what their children's needs are, if there are children, what their economic circumstances are, and what they're really trying to achieve and accomplish. Mm-hmm. It may be that, okay, well, maybe we put together a settlement agreement before filing for divorce, because some of those grounds for divorce we may still be able to preserve, like mutual consent, or if it's not separation for 6 months, irreconcilable differences down the line. But we can map out what that strategy could be.
And I will give an example because I know people are like, oh, stop telling me it depends. I want an affirmative answer. So just to give some context, like, I may have a client that the grounds for divorce may be the opposing parties arguing adultery. That could possibly be true. Well, maybe I don't want the grounds. If I'm defending that position, maybe we don't want the grounds to be adultery. So maybe we might want to wait till October 1st to allege the no fault grounds rather than adultery. And that may be beneficial for that particular client because you don't, judges read the file. We may not want those set of facts being read over and over again on behalf of our client. So it's possible that particular client, we may want to wait until October 1st.
So Sondra, this new law gets rid of the fault grounds of divorce, whether it's adultery, cruelty of treatment, abuse, desertion, constructive desertion. Would you tell somebody who experienced one or more of those things in their marriage and they come to you wanting a divorce on those grounds, and that is no longer an option as of October 1st? How can they still get some, an equitable outcome in their case?
And that is going to be difficult, right? We deliver difficult news, right? That's a part of why we counsel. We're attorneys to provide legal advice. And while we empathize that they have went through a marriage that was difficult and may have experienced what prior to October 1st will be at fault grounds and no longer exist, what I will tell them that when it comes to addressing the issues of a monetary award and alimony factors, that the grounds, the at fault elements of what happened in the marriage, we can still use those to argue to the court while this person should be entitled to a certain monetary award or alimony.
Right.
So while we cannot, and I know there's some people who have a certain religious background and their religion says, well, you can only get a divorce based on this grounds. I know that may be difficult, but this is still how we can use how your life experience is through the marriage. We can still port that over and discuss that.
So the court can still consider those elements or consider those details under a different lens.
Correct.
Under a different umbrella.
Absolutely.
Okay.
And relief, right? Relief. The relief that they're seeking, that monetary relief, whether alimony, we can consider it there.
Right. So the court can consider, technically, the the circumstances that led to the breakdown of a relationship when issuing an award of alimony or a monetary award. We can still fit those grounds that are no longer grounds into that category.
Right. All is not lost. Your story's not lost.
Yes. Well, I guess time will tell. We'll see how it plays out in the courts. I think everybody in the family law attorneys in Maryland are waiting to see how this plays out. We will too. We'll stay abreast so we know how to best prepare our clients.
Thank you.